Thank you. Yes, unless there is a different docket that was run. My run time is 2:40. All right, thank you. All right, Miss Johnson, I don't want to keep you waiting. You can come forward. Hello.
Hi, Judge.
Hi. And you always dress appropriately for court. You're always on time. I appreciate that so much.
Thank you, Judge.
All right, so I know you want a jury trial. We're currently in a jury trial.
Yes, ma'am.
So what I'm going to do, could I have a reset form, please? I'm going to reset you so you won't be here waiting.
Thank you,
Okay.
Judge.
And then I'm going to give you a reset date. State, this is criminal trial division.
Yes, Judge.
It's a DWI.
Judge, it's an assault.
Oh, sure, it is. Yes.
But maybe 2 days. So.
Do you want to set it for the week of April 21st? All right. Is April 21st that week good for you?
I'm in civil court with these people.
Sure, no problem. Just let us know. We'll accommodate your schedule.
Could we make it the 28th?
The April 28th, that's Fiesta week, and usually it's not good to have jurors during that week because they're thinking about Fiesta.
Okay, yes, May 19th is good.
All right, so we'll put you down for May 19th. I'm going to give you a reset form. And when your attorney shows, we'll let him know.
Thank you, thank you.
Yes. All right, the 20th would be jury selection.
Okay,
And then what will end up happening, if your attorney has any pretrial motions, he can always let us know he has pretrial motions and we'll either hear it the 20th or either he'll let you know that he wants to hear it on the 19th. If he wants to hear it on the 19th, you can appear by Zoom.
okay.
All right. So let me give you the reset form and then you are excused.
Thank you.
You're welcome. Miss Johnson, here you are. Hi. And if you'll just sign where it says defendant. And they have, oh, here you are. You're welcome. And I'll write it again on here because it didn't go through as well. There you are.
Thank you very much.
You're welcome. Have a great rest of your day.
Yeah. Will you have a second? Can I approach the judge, Gerardo Martinez? Gerardo.
Gerardo Morales.
Is it? Yes, hi. How are
Hi,
you?
how you doing?
Good, how are you this
All
morning?
right.
So I've spoken with the state, there is a discovery issue.
And where's your client?
My client's in custody.
All right, they're bringing him out, but
Oh, well,
what's the discovery issue?
I spoke with a material witness and I spoke with the complainant and, maybe they gave a different statement.
Okay.
So Andrew's gonna follow up on this for me.
All right, so how much time do you need?
A week would be great.
Okay. So you all want to bring it back the week of April 14th?
That works for me.
All right, what date, council?
How does,
I can give you the 14th, 15th, or 17th.
14th, 15th, or sell it to me?
14th, 15th, or 17th.
Oh, 17th.
Sell it to you. What are we selling?
The 17th would be good.
All right, so we're going to bring you back on April 17th for discovery issues. All right, Deputy, could you give me a reset form just, all right, April 17th?
They were not even bring them up.
All right, thank you. Mr. Goldstein?
Yes, ma'am.
Hi, do you need your client with you?
Uh, yeah, yes, yeah.
All right, Deputy, could you move him next to his attorney?
Thank you, Jim.
You're welcome.
We're gonna need one more chair, which I think. Well, I'm gonna need it right this second.
Okay.
Thank you.
Did you want me to come back on Ethan Rosales?
Yes, and just one second, let me send this email very quickly. Can I see the file on Ethan Rosales, please? All right, and is he in custody or on?
No, he's on bond. He said he didn't need to come. This is one where you were gonna see if they were gonna transfer it or if we're.
Yes. All right, thank you. So on this case, I still don't know if it's being
You want me to
transferred
come
or
back on
not.
Friday? I can just check back with you.
He's not gonna be transferred because that's the one that's tied with Nathan Martinez.
Okay.
So the other one is gonna be transferred.
All right, so your
Stays
client,
here.
your case will stay here.
Is Nathan Martinez staying here?
Yes.
Yes.
Okay, all right.
All right, so let me,
I'll get a new date.
all right, so if you can get a new date,
Can you get a 30-day reset, Judge, or?
well, what date is Nathan Martinez set for?
Well, so Nathan's got capital. My guy is a co-defendant on a deadly conduct case that got severed.
Okay.
So
Oh, they're severed. Okay.
we probably need a different court date.
All right, Norma, give me the date that Nathan Martinez is set and we'll set his case a little bit before Nathan Martinez.
Say bad things about Odyssey. It works great every time.
All right, so his court date is set, let me see. If he has something in the system, just one second. He's set for May 6th for a jury trial.
You want to
So,
do the week before, are you gonna be here for Fiesta?
no, I don't have court scheduled for Fiesta because people are doing their own things.
Yeah.
What I can do is I can set it. I can put you for the week of the 21st of April, or either it'd have to be on, I can put you on May 6th.
Um, let's, I'm picking a jury on a non-death in the 175th on the 5th.
Okay.
But I don't know what time she's gonna start evidence.
Mhm.
I mean, let's set it for the 6th,
Okay.
and then if there's an issue, I'll let you know.
All right. So we'll put it for May 6th. State, Ethan Rosales,
Yes.
May 6th.
And I'll let him know.
Okay, thank you.
All right, thank you, guys.
You're welcome.
And Judge, is that for trial or is that?
No, just a regular setting.
Okay.
All right. Is there anyone else who's ready? Could I see the file on Cortez Polk, please?
Yep.
Norma, let Ms. Pettis know she needs to be here today. And she needs to be here before 11. All right, are you all ready to proceed on Mr. McIntyre on the motions? Defense, are you all ready to proceed on the motions?
I'm sorry, Your Honor, I didn't realize.
Oh, no problem.
And the lawyer with the two cases, Monk and lots of things that we'd asked about.
All right, thank you.
He's in the room to the right. Hey, touch base again.
All right, the court is calling 2019 CR 12495 State versus Tamar McIntyre. Could I have parties announced for the record? State,
Megan Dowling and Jason Garahan for the state.
defense,
John Hunter, Jerry Goldstein, and Thomas Lane for Mr. McIntyre, Your Honor.
and are you Mr. McIntyre?
Yes, Your Honor.
All right, are parties ready to proceed on motions that have been filed by the defense?
The state's ready, Your Honor.
Yes, Your Honor.
All right, so the first motion that I have a motion to suppress and or exclude digital cell phone evidence. And then I also have a motion to suppress, and I believe that motion to suppress is related to the affidavit for search warrant. Is that correct?
Correct, Your Honor. On that same cell phone.
All right, thank you. And counsel, do you wish to proceed first on the motion to suppress as it relates to the affidavit?
As to the Heath matter, yes, Your Honor. I think that would be the best way to proceed.
All right, you may proceed.
Thank you, Your Honor. As the court will recall, in late January, the defense filed a sworn motion for continuance on the basis that there was some issues with one of our experts that we needed additional time to resolve. We supplemented that motion for continuance with additional information because on the day that I approached the court on that, the state tendered to me an additional external hard drive with data related to Mr. McIntyre's cell phone. The phone in question was taken from the black Kia that was found in a parking lot with of a Mexican food restaurant over off of San Pedro near the shooting, about a mile away, several days after the shooting. And it was searched, and ultimately, I believe it was determined that that was Mr. McIntyre's cell phone.
And I'm sorry, just one moment. So the small microphone,
Yes.
if you could put it on your lapel, it's for the court reporter to hear.
Yes, Your Honor. Thank you. The phone was originally a dump of the phone, and by a dump, let me be very technical, or at least as technical as I can be, not myself being an expert in digital forensics, was what's called a technical extraction. And it was the lowest level technical extraction. And some of the data on that extraction was not intelligible. And the PDF copy that was tendered is not interactive, meaning that we are not able to open applications and look at the metadata. We're not able to look at the content of messages that were sent through third-party
Right.
applications.
So counsel, this is my question. Are we starting with the search warrant first
No, Your
on
Honor.
whether, so you don't want to start with the search warrant first
I'm
on
just-
whether or not it's the judge who found that the search, that there was probable cause. You don't want to start with that first. You want to start with discovery first?
Well, I'm happy to proceed with whichever Your Honor wishes to proceed with first. I just thought it was simpler to discuss the discovery matter because the court, some of our discussions previous at the bench indicated that the court also had a concern about the production timeline. And so that's how I was going to proceed. But if Your Honor wishes to get into the motion to suppress first, I'm fine to do that.
I think it will be easier to start with the affidavit for search warrant, because if the court finds in your favor, then there's no need to discuss the other portions. So I think it may be best to start with that first, the taking of the cell phone, the extraction of information from the cell phone. And then if the court does not rule in your favor on that, then we can go into discovery.
That works for me.
All right, so we'll start with your motion to suppress as it relates to the affidavit for the search warrant.
Yes, Your Honor. And I believe for the record, the state tendered to Your Honor a copy of the affidavit for the
Yes, and if-
application.
Yes, and if you all would like to have that marked for purposes of the record for appellate purposes, I would suggest you all have that marked with the court reporter. And you can mark it as, if it's going to be tendered by the defense of the state, you can either mark it as D1 or D2R, which will signify it's for the record, or either states 1R, however you all want to do it.
Yes, Your Honor. I can mark it as two. Well, I guess it is. It's
Well, I have it.
It's y'all's warrant. So we'll make it states are one.
Yes,
That
I
works.
showed it to Jerry yesterday, but you.
I think it's the same as ours. Yep.
And what's being marked as states R1, do both parties have a copy of that?
Yes, Your Honor.
Yes.
And for those of you who are on docket and you're waiting for your attorneys, you have the court's permission to step out in the hallway and call your attorneys, because we're going to be recessing today at 10:45 because I have a meeting to attend. And if your attorney's not here, you're going to be brought back in the afternoon.
Yes, Your Honor, state offers state for one into evidence for purposes of the hearing.
Any
No
objections
objections.
for purposes of this hearing?
No, Your Honor.
All right. And for the record, the state had previously tendered what has been marked as states R1 to the court with no objection from the defense, so that the court could review it in anticipation of this hearing. Is that correct, defense?
That's my understanding. Yes, Judge.
All right. So with regards to the affidavit for search warrant, defense, you may proceed.
Thank you, Your Honor. The application that's been tendered as states R1 is, in our estimation, and we believe the court will agree with us, insufficient to confer probable cause to search this phone. The contents of the warrant application detail roughly what I was explaining a moment ago, which is the way it was discovered. It was found in the center console of that black Kia, the 2013 black Kia Forte, that the officers believed was the vehicle that witnesses observed at the Chick-fil-A a few days earlier. In the warrant application, the officer details what can best be described as a boilerplate recitation of things that one would expect to find on any cell phone in the United States. Text messages, incoming and outgoing call logs, data associated with that, memory cards, subscriber information, et cetera. Then in the probable cause section of the brief, which begins about 2/3 of the way down the first page and continues on to the second and last page of the document, the officer details information that's roughly a fair summary of what the court has already heard in the trial testimony in this case, namely that witnesses saw a man in an altercation on the access road of 410 near the Chick-fil-A, that that man was out of the car. He got on the hood of the car. And then the vehicle pulled into the parking lot of Chick-fil-A. The man stood up and kicked the windshield, and someone inside the vehicle leaned out of the car and shot the deceased one time and fled the area. The affidavit also specifies that they recovered the cell phone of the deceased as a result of that preliminary investigation on the 23rd. And then on the 24th, they obtained a warrant for the records related to the cell phone of the deceased, Mark Anthony Saldivar. The review of those records divulged that there had been extensive correspondence with a person using a phone number 210-331-8356, which officers ascertained belonged to Joanna Marie Reyes, who also was registered as having possessed a black Kia Forte, which is the vehicle in question. Then a bolo was put out for that vehicle, and after several days, it was eventually located in this parking lot where it was then impounded. And a blue iPhone with a cracked screen was found in the glove compartment. That's the recitation of facts. Then what I would submit is the mere conclusory statement that is the hobgoblin of courts everywhere. We immediately proceed to a bullet-pointed remark that affiant believes the search of the above described thing for the above described items will constitute evidence that the offense of capital murder was committed on April 23rd, 2017 in Bexar County, Texas. There is, we've submitted in our brief, Your Honor, a citation to Baldwin versus State, which was a case, I believe, originally out of the 14th Court of Appeals in Houston that was granted discretionary review by the Court of Criminal Appeals and was issued, I believe, in 2023. In Baldwin, the court is concerned with the issue of using boilerplate conclusory language to authorize access to cell phone data, recognizing, as we must in the wake of Riley, that a cell phone contains all of a person's most intimate details, from their correspondence with other people to their location, to their medical history, their banking records, everything. And that therefore the warrant requirement must be strenuously observed in searching the contents of phones. And we know that the Fourth Amendment requires particularity as to the place to be searched and the things to be seized. Things to be seized, I think, being the operative concern that the court had in Baldwin. The issue needs to be framed in terms of the affiant seeking access to a phone under these circumstances must draw a clear nexus to the matter that's under investigation and detail why he has probable cause to believe that those things will be on this phone. The officer does not do anything that would establish that. This document does not explain why they would have any particular reason to believe that that cell phone is the phone that would be associated with the number that was later connected to Joanne Reyes. And as we'll get into, if we proceed to the Franks aspect of the argument, we do definitively know that it's not the phone number for that phone that was recovered. And that there's very good reason to believe officers already knew that when this application was drafted. But I digress. Looking at the four corners of it, the officer doesn't do anything to explain why they would have reason to believe that that particular subscriber data for Joanna Reyes would be connected to this specific blue iPhone. It also doesn't explain why, even if it is connected to this blue iPhone, that would necessarily entail a right to search the contents of it. Even if they are able to ascertain that this deceased individual corresponded with someone named Joanne Reyes, that doesn't give us any indication that the phone was used in the commission of the offense, that the phone contained information that would establish a motive to kill or specific data related to the issue of whether or not it truly is a capital murder, or whether it's a robbery, or anything else about the offense itself. What's generally, I think, done here and is asking the magistrate to read between the lines and conclude is that criminals use cell phones, and that if a criminal has a cell phone on his person, it must contain incriminating information necessarily about that person's location, about that person's comings and goings, about the people that that person spoke to. But the court in Baldwin recognizes that, of course, that's true because everyone has a cell phone. Criminals and non-criminals alike use cell phones. Any person's cell phone would be able to provide all of the information about that person's comings and goings and correspondence. That's not the kind of nexus that we're talking about. And it dovetails with a concept that's been regularly recognized, which is there is no homicide exception to the warrant requirement. Routinely in homicide cases, the location where the death occurred or a suspicious place that is associated with the homicide is treated as though, I guess from a law enforcement perspective, the aim would be to say, okay, we believe that this is a suspicious place in conjunction with a homicide, or this is the situs of a dead body that we believe was killed illegally. We want to coordinate it off and preserve it in amber and say, this is ours now. We control it. It's our crime scene. We need to make sure for scientific reasons, for evidentiary reasons, that we are the only people that are able to influence what's going on, to collect and seize, to search. And that's not the case. And so while certainly a suspicious location like an abandoned car or a residence where a dead person is found under suspicious circumstances might be a variable that needs to be articulated in a warrant for search of that residence, search of a phone, search of a vehicle. That isn't the be all and end all of whether it does get searched and whether everything within that particular area gets seized. It isn't a carte blanche situation. But when we read this warrant in its totality, it's clear that that's the assumption. The officer does not tell the magistrate any particular reason why he would have any reason to believe that this phone is going to be of greater evidentiary value than the phones of other individuals in the Chick-fil-A parking lot that day, other individuals in the parking lot of the Mexican food restaurant. And that's, I think, the problem.
But isn't when you read and stay within the four corners of the affidavit, isn't it mentioned that the black Kia vehicle, that they have a license plate for the black Kia vehicle, and that black Kia vehicle is tied to the Kia vehicle that they're saying was abandoned at the Chick-fil-A?
It does say that, Your Honor, but interestingly, and one moment to make sure I'm
Sure.
correct about this. It doesn't even say, I think I can get where the court's asking about.
Mhm.
If we look at the things to be seized on the suspected thing,
Mhm.
which is the second bullet point of the application, it doesn't even talk about GPS or sword site location data.
No. I'm just going to your argument where you were saying that how is this any different than just seizing people's phones that were at the Chick-fil-A or parked at the Chick-fil-A? But I think that both parties can agree that the cell phone that was seized is a cell phone that is from inside the vehicle. I think we can do both parties agree that it was a cell phone that was seized from inside the Kia vehicle?
Yes, and that absolutely cuts to the bone of the question.
No. So I'm just going by your argument when you say, based upon this search warrant, anybody's cell phone from any vehicle at the Chick-fil-A could have been seized based upon this. But in the affidavit, they are only seeking to seize the phone from a Kia vehicle, which within the four corners of the affidavit, they have reason to believe that it was involved in some type of offense. According to this, they believe capital murder. And because the defense, you are not filing a motion to suppress the search of the Kia vehicle, I'm assuming, and if I'm assuming incorrectly, let me know, I'm assuming that you have no problem with the actual search of the Kia vehicle. Your only problem is the retrieval of a cell phone from that vehicle and the search of that phone. Am I correct?
Yes, Your Honor, we don't have standing to complain about the Kia, so I can't speak to whether that warrant was valid or not. We don't have a right to complain. It's not our car.
All right, so you don't have any standing to complain about the Kia vehicle.
Correct.
And you assume, or are you stating that you have standing to complain about the search of the cell phone?
Yes, we have standing to complain about the search of the cell phone because it's our cell phone.
Okay.
And well, just one second. The thing.
And mind you, everyone, I'm just asking questions so I can be clear on everyone's argument.
Yes, Your Honor.
Okay.
And I wanted to be sure that I had a chance to be heard. That's-
Oh, yes. Here's the thing, everyone. You will all have a chance to be heard. I just want to make sure we pare down to what the specific issue is. All right, you may continue.
Yes, Your Honor. And so the issue of the seizure of the phone is, I think, I mean, it would be very difficult for us with a straight face to argue that we can object to the seizure of the phone because the phone was discovered in a vehicle we don't have standing to complain about. But obviously the phone is locked. It has its own contents. The contents are Mr. McIntyre's private matters and affairs. We have a right at standing to make that complaint. The problem, I guess, would be to put it another way. Let us assume a hypothetical in which we all know who the killer is. We saw a person that everyone recognized discharge a firearm in broad daylight in public, and he was followed to a specific location and he was arrested. And yes, Your Honor.
All right, you may continue.
Sorry, Your Honor. In that hypothetical where we know that this individual is the killer and we have followed them and arrested them and we've acquired their cell phone incident to lawful arrest, the mere fact that the individual possessed a cell phone on him and we know that he is the killer, I don't believe under Baldwin would give them by itself probable cause to searching. And that's functionally what we have here. We know that this car was used in a homicide. That part seems to be beyond any meaningful dispute, at least not that we as the party could raise. And now, having acquired that, we found a cell phone. But that's just, that's literally all the officer seems to think is necessary is. This car, like a known identified murder suspect searched into arrest, is involved in a homicide, so therefore we get to search the phone. And there doesn't appear to be any additional legwork. And that's really hard to accept, knowing that like the phone's in their custody and they had a warrant to seize the phone pursuant to what was authorized by the search of the Kia. And so in terms of whether or not this would, I mean, there's no excusable reason why there could not have been corroborative effort or due diligence to actually build that nexus that Baldwin talks about.
All right, and you're saying that this cell phone that was seized and searched is your client's cell phone?
That, yes, Your Honor, that appears to be the case.
And they allege that, Your Honor.
Okay.
And if I can just interrupt
yes.
for a second. If you think about it, and I would call the court's attention to Riley versus California, which was a unanimous Supreme Court case, which there aren't many in the Fourth Amendment, written by the Chief Justice. It was a case where a cell phone was legally seized from the defendant. However, remember, it was search incident to an arrest. The court said you need additional probable cause to search that the contents of the cell phone, even if you have legal possession of it. And in Riley, they talk about two additional matters. One, they talk about what cell phones are, that there are more cell phones in the United States than there are people. Everybody has a cell phone. And they talk about with all they contain and all they may reveal, they contain the privacies of every citizen's life. And the Chief Justice goes on to discuss the fact that cell phones, interestingly enough, have a nexus at the crossroads between the Fourth Amendment and the First Amendment. And that because of that, because they contain communication, which are the contents of that cell phone, it requires not just probable cause, but particular exactitude when you're looking at probable cause. And what it lacks here, and the court talks about the fact, otherwise, we could assume that anyone convicted or charged or arrested for any crime, suspected of any crime, you could search their cell phone because you might expect to find some evidence. The requirement of this by the Supreme Court of probable cause is that it be particularized as the thing to be seized. We got the seizure, just like they had in Riley, as well as the person or items to be searched. And that's what is critical here. There is no probable cause. They do not allege any probable cause to believe. What evidence would they expect to find on this particular phone? It is not a general idea that, well, you committed a crime. It looks like you must have planned something. Surely there must be something on your phone that shows something like.
So you all have no objection to the fact that the cell phone was seized.
I don't think we have standing to complain about that.
All right, so your only complaint is extracting information or data from the cell phone. Is that
Searching
correct?
the contents of the cell phone.
Access to it, yes, Your Honor.
Okay. All right, you may continue. I'm sorry for the interruption.
You didn't interrupt anything and I'm finished.
All right.
I
Is
think
there
that-
anything else?
I think that's our argument. Basically, this warrant says that because it's a phone, it must have incriminating evidence on it. That's mere conclusory. Baldwin has disavowed that kind of boilerplate work. This is a boilerplate warrant. And I mean, it stands to reason it would be. This is a 2017 warrant. The state has had ample time to reissue a warrant if they wanted to. We think that this warrant's defective. We'd ask the court to find that it has no probable cause.
All right, in just one moment. All right, so what I'm reading from the affidavit is it states that the Kia vehicle, which defense you say that you have no standing to object to the seizure of it or the actual search of it, that Kia vehicle, according to the four corners of the affidavit, was driven by Joanna Reyes, and that Joanna Reyes has custody of the Kia.
You could be right, Your Honor. I think it
From
says
page 2,
it was,
from page 2 of the
yes,
affidavit,
I think that might be,
paragraph 3. It
Right.
says that Reyes informed your affiant.
well, she also drives and has custody of a black Kia Forte. In other words, she owns
Yes.
one, but I don't think that the affidavit is saying that she was driving it on the day in question. I think that that's an important distinction to be careful
right.
about. I don't think that they've confirmed that she's the operator on the day in question, just that she owns that make and model vehicle.
All right. And then it says she drives and has custody and control of a black 2013 Kia Forte, and it has the license plate number and the VIN number listed.
Yes,
right, is
but they found it abandoned in a parking lot, so we know she wasn't driving it at the time that they seized it.
No, I understand your
That's
point.
all I'm saying.
So the affidavit says that. And then in the paragraph, the first paragraph, it says that in reviewing the records, your affiant noted that the victim had been in contact with the person using a phone number, and they list the number, over a period of approximately 2 hours from April 23rd, 2017, 2:53 p.m. to April 23rd, 2017 at 4:48 p.m. And the reason why I bring that up is because, and maybe you would like to address that, because one, I understand that sometimes there's boilerplate where people just want to search everything. Hypothetically, sometimes there's someone who has a drug case and they're in a vehicle and people believe, we found drugs, so now therefore we get to search everybody's phones. And there's no connection between the alleged offense and the phone. But on page 2 of this, you have someone using a phone number that they mentioned in paragraph 1. Then you have Joanna Reyes, who they're saying had control or custody in control of a black 2013 Kia Forte. So do you want to address the fact that in the affidavit, they're having a phone number, and then you're having this black Kia that they said was in the control of Reyes? Do you want to address that?
Yes, Your Honor, I think we can. A couple of things. As I was saying earlier, the affidavit identifies that the woman that Mr. Saldivar had correspondence with on the day of his death was in fact that she is registered to own or drives and has custody and control over. I think what we would find out if we dug into that is it's actually a man that they say is her husband.
Mhm.
But that she has a Kia Forte that's black.
Mhm.
That doesn't that again doesn't establish that they have definitively determined that the black Kia Forte of Joanna Reyes is in fact the same black Kia Forte that was at the scene of the Chick-fil-A. They just are saying that they believe they have that. But more to the point, Your Honor, I think here's the most important thing we need to note. We know that there is no recitation of corroborative detail anywhere in the affidavit. In other words, apart from the fact that this was found in a black Kia, and they know that Joanna Reyes, a person that Mr. Saldivar spoke to that day, owns a black Kia. They have not done any additional corroborative detail that is particular to the phone. And more importantly, and this is where I think it gets interesting, and obviously this issue will become also significant if there's a Franks hearing, but it's important for the Four Corners because the officers tell us in this application that the telephone of Mr. Saldivar was tossed out of the window of that black Kia on the day of the shooting and that it was recovered. And they know from that follow-up and that search warrant application for the deceased's phone issued on April 24th, the day after the killing, that's how they come to know that he's been corresponding with this 210-331-8356 telephone number that they eventually establish as Joanna Reyes. What that tells us is they have the phone, they've been able to acquire information on it, but they've spoken of no additional corroboration. The thing that immediately comes to my mind is it would be rather simple for them to have called that phone number using the deceased's phone number and determining whether or not the phone that they seized from the black Kia rang. And that isn't in this affidavit. Nothing of that nature is described, nor is any other investigative effort leading up to the right to get into this person's phone undertaken. They have decided, or they have assumed, that because black Kia Forte is the suspect vehicle, make and model, they found a black Kia Forte belonging to someone who has a phone number that was in Mr. Saldivar's phone, that somehow is the nexus required for them to be able to search the blue cracked iPhone found in the glove box. But that it hasn't said anything about the blue cracked phone on the glove box.
All right, and counsel, your co-counsel wants to show you something. Yes.
And Your Honor, while they're doing that, if I may, Judge, the issue of the black Kia entitles them to seize it, just like in Riley, they were entitled to seize the phone. The question is whether there's probable cause to believe there's something in the contents. They got a search warrant for Joanna Reyes's cell phone separately. And that tells you that they understand they need that. And the problem here is that whether they came into possession of the phone, just like in Riley, the unanimous Supreme Court case, there's a separate issue requiring, and the Supreme Court makes it pretty clear. The Chief Justice says the question of what the law enforcement needs to search a search warrant, I think I'm quoting it pretty correctly, is simple. And it's dash, get a warrant to search it, even though they had possession of it. So the fact that it was connected with the vehicle is fine, but the only call that they might find that they are looking at that says, okay, the guy used his cell phone is to a different phone. They get a search warrant for Joanna Reyes's phone. There is no search warrant to search the contents of our client, Mr. McIntyre's cell phone that says, that gives probable cause to believe they have particular probable cause, and I believe the phrase I said, particular exactitude, I think the language of the Chief Justice was copious exactitude, that they expect to find something on that phone. Otherwise, every time they make an arrest and they find a cell phone on the person that they believe committed the crime, you might find something on the cell phone. The guy made a call. Well, everybody makes calls.
All right, so your argument is that there is no nexus between the extraction of the cell phone data and the offense. Is that what I'm getting from your argument?
There's
No
no, there's
proper
no
detail,
probable,
no nexus.
there's no particularity with copious exactitude that they know that or believe, have probable cause to believe there's something on that phone any more than there'd be every time they arrest somebody and find a cell phone.
Okay, all right, thank you. All right, state.
Judge, just before I get started, I just wanted to make sure for the purposes of this hearing, they are stipulating that that cell phone that was located and the black Kia Forte belongs to Tamara McIntyre.
Your Honor, I
No,
think
they
that-
allege that.
their allegation alone is
Alleged.
sufficient to confer us standing. And under Simmons, the defendant is not required to forfeit one constitutional right in order to assert the balance of another. The government has alleged that this is Mr. McIntyre's phone. And I believe that that is sufficient for us to have standing to have a complaint about the way in which it was searched. If the court disagrees and wishes us to make that stipulation, we can talk about that, but I think it's inappropriate for them to be asking that question.
Well,
And if we did, we
what-
do
what-
it under Simmons, Your Honor.
Well, this is what I'm telling everybody. I'm strictly going by the four corners of this affidavit, which I'm bound by the four corners of this affidavit. And within this affidavit, it doesn't say anywhere that this cell phone is your client's cell phone. So I'm strictly going by the four corners of this affidavit.
I think
Well, I
standing
get-
is generally speaking, not required to be within the four corners. I
Well-
believe that standing can be demonstrated outside of the four corners of the warrant.
Well, I will say this, your co-counsel stated that the reason for the defense not complaining about the actual search of the Kia is that you all did not have standing to complain about the search of the Kia.
We did.
And
say that.
within, yes, and within the affidavit of the search warrant, it states that the officer who wrote the affidavit through witnesses or however he obtained the information was that the Kia was under the custody and control of Reyes. And so at the beginning of the defense's argument, the defense stated they did not have standing to argue about the search.
No, seizure.
No. Counsel said that y'all did not have standing to complain about the search
Of the Kia.
Of
of the
the Kia.
Kia because,
Or
The Kia-
seizure of the phone.
yes, because the Kia doesn't belong to your client.
That's
What
correct.
I'm saying is, in the four corners of the affidavit, it does not state to the court that this cell phone that was seized belongs to Mr. McIntyre. If it does state that, please bring it to my attention because maybe I didn't read that.
The warrant does not say that, Your Honor. That's
Okay, all right.
correct.
All right,
And-
so
and-
let me do this. Time out. Let me hear the state's arguments. And then you all will have a chance to address whatever argument they raise. Now, it
And the
appears,
state asked, would we stipulate to the standing, to our standing as the owner, possessor of that phone? And we will under Simmons, which is for purposes of this hearing, we agree that that is our phone, and we do that stipulation with my client present under Simmons with the obvious Simmons caveat
so-
that we're not agreeing that we possess it for any other purpose at trial.
all right, so they're stipulating that the cell phone that was seized belongs to Mr. McIntyre.
Yes, Judge, so that's all I was asking. So I'm gonna be referring to State v. Baldwin, and the site for that is 664 Southwest Third 122. And so I just want to make sure that the court, as you've said, is bound by the four corners. I know there's been a lot of extra facts thrown out by the defense in their argument. However, that case states that probable cause for the issuance of a search warrant exists under a totality of the circumstances. There's a fair probability that contraband or evidence of a crime will be found. And so if we take a look at the search warrant regarding the suspected thing that is to be searched, that information that's contained within there is not boilerplate. It's referring to text messages, incoming and outgoing calls, and additional data and information to determine who the owner is. That is corroborated, the text messages and the call logs with inconsistent with what is later stated that I'll move on to, which is that on April 24th of 2017, the affiant did apply for a search warrant for the cell phone company records of the victim, Mark Anthony Saldivar. Upon receiving that information, he did observe that the victim was in communication with the listed phone number for approximately 2 hours before the murder. And so that is states in the four corners that the murder occurred on April 23rd of 2017 at approximately 17:22. And we can look at that in comparison to the hours of communication, April 23rd, 2017, from 2:53 p.m. to 4:48 p.m. So that's immediately in the vicinity of the murder. Using law enforcement databases, the detective then links that phone number to Joanna Marie Reyes. He receives information that Joanna Marie Reyes drives and has custody of that black 2013 Kia Forte. And so it's a reasonable deduction, Your Honor, that that was the phone, that the phone contained in the black Kia Forte was used to communicate with the victim. And we have eyewitnesses that say that black Kia Forte is the car that and that's contained in the four corners. If I can just have a moment to find it, Your Honor. The witnesses observed the victim inside of a dark colored vehicle, and that it had windshield damage. And so they get the make and model of the black Kia Forte, 2013 Kia Forte, the license plate, and a VIN number. And that was corroborated with the surveillance footage as listed in the affidavit. Furthermore, there was a be on the lookout placed, and that's how they came in contact with that 2013 Kia Forte. And all of that information is matching the license plate and the VIN number. And so just going back to Baldwin that I cited earlier, that case further states that the reviewing courts should give deference to the magistrate's probable cause determination, and even in closed cases, give great deference to the magistrate. And when in doubt, reviewing courts should defer to all reasonable inferences a magistrate could have made in issuing the warrant. And I think that the Baldwin case is in direct conflict with the facts that we have here. The issue in Baldwin was that the affidavit that was contained in that case did lack particularized facts. And so the fact scenario in that case was that the affidavit indicated nothing more than that neighbors saw a certain white sedan with a black driver circling the neighborhood the day before the murder occurred, and that defendant, a black man, was driving the very same vehicle 4 days after the offense. And the affidavit contained nothing about a phone being used before or during the offense. That is in complete contrast with the facts that are contained within the four corners of the warrant that we have in this case. And so I would argue that there is no boilerplate language, and we're asking the court to deny the motion.
If I may, Your Honor, just briefly,
Yes.
the most important word in this entire document that defeats her primary premise is the word occupants, which is in the 4th bullet point of the first page, second paragraph. Witnesses were located that observed the victim inside of a dark colored vehicle shortly before the shooting. The victim was forced out of the car and continued to argue with the occupants of the car. The victim jumped on the hood of the car as it began to move. Occupants, the plural, is the primary reason why the only argument I think that it was worth considering there has to be rejected. She's saying that the magistrate could draw a rational inference that because the phone is located in the car and the car is believed to be the car that was involved in the shooting, it must be the cell phone that Mr. Saldivar was corresponding with. But we know from the word occupants, there are multiple people in that car other than the deceased. And that would ostensibly mean that there could be more than one phone. That would be the reasonable inference. So the reasonable inferences that a magistrate would necessarily have to draw from the use of the plural in that paragraph is that he has no particularized reason to believe that this phone is the phone that Ms. Reyes possessed and corresponded with Mr. Saldivar on. And because of that, it is a boilerplate mere conclusory statement. Also, she said several things there that just, I think, take the application out of context. The second bullet point on page 1, very plainly, is just a boilerplate recitation of things that every cell phone in the world would have on them by nature of being used as a cell phone. And none of it is to say that there has been any investigative effort to determine whether this phone has those things on it, whether the things it has on it have relationship to the offense that they're investigating or anything else. It's just a laundry list that could be copy pasted into any warrant under the sun that's talking about cell phones.
And if I'm correct, Your Honor, when you look at, if I may, Sherry Gold, say I'm speaking loudly because I didn't pick up on mine, and I apologize. It is the state's position that because the victim used their cell phone to call numbers, they know what number this cell phone is. And the problem is there's no indication that that they had any information that the victim's cell phone ever called the cell phone in question, which for purposes of this hearing, under Simmons, we have stipulated as ours. So the other cell phones that people might have had, if they had a number that corresponded with the numbers that were called or texted to or Instagram or whatever they were going to do to them, but there's none of that. So what you have is just a random cell phone, and we're going to look at it just since it was found in the vehicle where the related to the offense, we might find something. There's no indication that that was the number called. As a matter of fact, it wasn't.
I would just point out.
And they could have found that out if they did. They may have known it, and that relates to the Frank hearing that we may have to have, but that there's nothing to suggest that they have any particularized with copious exactitude, particularized probable cause to believe there's anything on that phone, and certainly not a call from the victim because there aren't.
All right. So this is what the court is going to do. Defense's motion is denied. Let's move on to your next motion.
But, and yes, Your Honor, before we, just so I'm clear, the motion in question seeks essentially two alternative paths for suppression. The main thrust of our argument is the Baldwin claim. But as Mr. Goldstein has pointed out, we believe that both with Mr. Goldstein's proffer and also the proffer made in the motion itself, that we have made the thresholds showing that would.
All right, so everyone, this is what I want to tell you all. I've heard your argument. I've allowed both parties to present their argument. The motion is denied. So we're going to move on to your next motion. So what I'm denying, so that everyone can be clear, the court is denying your suppression or your motion that there was no probable cause for the search warrant. The court is denying that. The court is finding, based upon the affidavit for the search warrant, just the four corners of the affidavit, that probable cause was presented to seize the cell phone, to extract information from the cell phone. So let's move on to,
May we be ensure that the record reflects, is the court saying that you're denying our request for a Franks hearing based upon the fact that we believe we have made a showing that we're entitled to that hearing, Your Honor?
No,
That's
what-
beyond
no,
you know,
the
under
first,
Franks, you assume that there's probable cause. In the
All right,
warrant,
so-
you're just suggesting that there's reckless or intentional misstatement.
all right, so here's the thing. This entire hearing that we have been having, defense, correct if I'm wrong, you've been requesting the court to find that this affidavit for search warrant, in layman's terms, should never have been signed by a magistrate judge. Is that correct?
Yes, Your Honor.
All right,
The
so-
The four
so-
corners argument is
so-
what you're denying.
So I am denying that.
Right.
So we're moving on to the next step.
Which is
So
the Franks hearing.
all right, yes, that's what I've been saying.
I didn't realize that, Your Honor.
No, no.
I apologize, Your Honor. I put both theories in the same motion.
All
so
right.
I just misunderstood you.
That's okay. So we're just doing one step at a time.
So
I think it's important to do things one step at a time so the record is clear. And so the record is clear. Your argument that there wasn't probable cause for this magistrate to grant the officer or whomever it may have been to seize this phone, which you said there was no objection to seizing of the phone. Your objection was to the actual search of the phone, which would mean extracting the data. The court is denying your motion as it relates to the affidavit of the search warrant. So let's move on to your next argument.
Yes, Your Honor.
So the search warrant, the court is finding in favor of the state with regards to probable cause within this search warrant to search the phone, because you have no objection to the seizure of the phone. Your only objection was to the extraction and obtaining of the data that was located within the phone. So that part of the defense's motion is denied. So let's move on to the next part.
Yes, Your Honor.
Yes.
The next argument that we would like to make is that we believe that some of the things we've discussed with the court this morning that we know are outside of the four corners of the affidavit, vitiate probable cause, that undermines what the affidavit purports to confer. And in particular, what we're saying about this is, number one, we know that the police immediately upon seizing Mr. Saldivar's phone called numbers that were on that phone to try and develop suspects and leads, and would have also called in the course of that, based upon what the affidavit is displaying, the number that they later determined belonged to Joanna Reyes. And so on just the most simplistic basis of understanding this, the police had all of the appropriate equipment, and I believe did ascertain by just simply calling the phone that the phone they seized from that Kia doesn't ring when you dial Joanna Reyes's phone number, which is that 331-8356 number that's in the warrant application, which would have absolutely wiped out the insinuation of this affidavit. That
All right, so here's the thing. I don't have anything before me unless it's in that affidavit that suggests they called a number and that number that they call didn't go to the seized cell phone. Is that in the affidavit or is that another argument outside of the
That's the
court?
Franks.
This is- what I'm now trying to ask the court is for permission from the court for us to have an evidentiary hearing to understand whether or not, going outside the four corners of the affidavit, the officers were intentionally misleading or recklessly disregarding of the
No, I
truth.
understand what Frank's is, but I just want to, it's not in the affidavit. So you're trying to state that the officer either was untruthful or misleading in his obtaining of a search warrant?
Yes, ma'am.
All
My,
right.
my position is that the evidence would show that the police were calling the phone numbers on the deceased phone and would have been able to determine through that this is not the phone number that was used, and I believe they did do that. I also
And didn't
believe
tell the magistrate.
that they had Joanna Reyes's cell phone already in their possession when this warrant application was filed. And so they knew when they filed this application that they weren't going to be cracking into Joanna Reyes's phone. And that is very misleading based upon how this affidavit is drafted.
And that's why they got a separate warrant for her.
Those are what we believe the evidence would show if we were able to go behind the four corners. And so we'd like to be able to have testimony and for the court to consider that what's being said here is just not true. And that.
So you want to call an officer to say that within the four corners of this document, this is not true what they've given to the magistrate? Are you saying it's
There is a
misleading?
misstatement that if excluded would render the warrant lacking in probable cause.
What
And I think that's
misstatement?
the essence of Frank.
Well, the way that I read this warrant, Your Honor, I read the warrant and I say to myself, as we've already argued, I'm not rehashing it, that it never connects this phone to Joanna Reyes's phone number. It insinuates it, it implies it. And I think that the state's argument on the four corners is it's a rational inference from this
But no,
document.
what are you bringing to the court to support, other than conclusion statements, what are you bringing to the court to support that this officer was misleading or that this officer was untruthful? That's what the court wants to know.
What we're bringing, what we believe we can demonstrate is that they issued a search warrant number 2017 W0295 for the phone records.
Excuse me, slow down with your numbers because remember, the court reporter has to take it down.
They issued warrant number 2017 W0295 for phone records from Verizon for Mark Anthony Saldivar's phone number 210-382-3826. That they issued a warrant number 2017 W0308 for the phone records from Sprint PCS account for Joanna Reyes's cell phone number 210-331-8356. Then they issued a warrant for number 037672 for Joanna Reyes's black Kia Forte. And then issued a warrant number 2017 W0405 for a forensic search of the blue iPhone belonging to Tamor McIntyre found in the black Kia Forte. The position we would take is that they already had ascertained Joanna Reyes's records and knew that this cell phone was not Joanna Reyes's before the blue iPhone was seized, or at least before the application was signed. And that what is represented here, that the reason why they don't just come out and say it, because if in fact they really believed, as this warrant implies, that they were going to find Joanna Reyes's cell phone when they cracked into it, they could have just said that.
But in the affidavit, it clearly states on page 2, using the clear search engine and other databases, your affiant determined that the phone number was being used by Joanna Marie Reyes.
210
And when they're
8356.
speaking, no,
That's a different phone.
That's a different phone.
that's what I'm saying. So you're saying that this officer was being misleading when clearly in the four corners of the document of the affidavit for the search warrant, he is telling the magistrate that he has a phone number, that number ending in the number 56, and that's in paragraph 1 on page 2. And then in paragraph 2 of page 2, he says, using the clear search engine and other databases, your affiant determined that the phone number was being used by Joanna Marie Reyes. So nowhere in the affidavit does this officer state or try to state that the phone number that they seized, the iPhone, that in some way was Joanna Reyes's cell phone, and that they knew, and thought that cell number was Joanna Reyes. That doesn't say it anywhere in this affidavit. I mean, am I incorrect?
That's part of why I think that the court should reconsider the probable cause question. The only
No, it's
only
denied.
reason why this warrant should have issued is if it would be reasonable to read the warrant as suggesting that there was a reason to believe it was Joanna's
All right,
phone.
so here's the thing. The court is finding that probable cause existed for the magistrate to sign this warrant. The court is denying your motion for a Frank's hearing. The court is finding that defense is merely presenting to the court conclusionary statements, and that what the defense is presenting should be addressed during cross-examination. If you all could give me just one moment, please.
I'll enjoy.
Yeah, yeah. It's.
Because the other one has an A and a B. This one's not coded. It's C and read the outside. Well, got me saying, that I transferred in there and I'm like, no, the prosecutor said. But I didn't.
I'll go talk to the prosecutor.
Yeah.
So you just let me know. What you want me to do? You already transferred it back. I'm like, no, because it has the same offense.
All right. No, it is.
All right, everyone, please be seated. And sorry, everyone, that was a matter I needed to take up with another judge, so.
No problem, Your Honor. I believe, my co-counsel, will be back shortly. He went to the restroom.
Oh, no problem.
I'm gonna pick up a microphone, I think.
Sure.
You left it here. That's right. Are you able to hear me?
I'm hearing you.
Jerry, I think you are one of the few attorneys we've had in here that I've never had to say, would you please speak up? I can't hear you. So I really appreciate that.
I think some people would rather I shut up, but
Oh, no, 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 no.
thank you. I believe he's gonna take up the heat motion next.
Okay.
Oh.
And Cindy, for some reason, I'm not picking up your
You're not getting the
real time now.
Really? I
Yeah.
checked to make sure it was coming.
Um,
I opened it up on my end so I can see if it went
all
through.
right, I'm gonna try it again because I tried to get everybody to slow down with numbers.
Okay, that works. Yeah, because there's a way for me to check on my end to make sure that it's opening.
Mhm.
And so it.
Your Honor, if I may,
Yes. Oh, just one second. She's checking
Yeah,
something.
it's open on my end, so.
Yeah, it says bad password or something.
Oh, it did that to me too.
Mhm.
It's a lowercase. It doesn't ask for your, does it ask for a password when you open yours?
Can you just type in test and I'll see what comes up?
Okay.
Because so far nothing is coming up.
I put testing.
The court had asked as I was coming in about
The NCIC, TCIC? All right, thank
These
you.
are two cases, the Monk case and the Watkins case, Your
Sure.
Honor.
All right, I'll review it.
They are 2006. They predate the Michael Martin Act, which was passed in 2013. I would point out to the court, for purposes of our request, that if the text of 3914A says we're entitled to copy, retain, all sorts of items
Well,
that,
not the NCIC. It says that they have an obligation to provide you with Brady.
I understand,
but-
sir. Those are before the Michael Martin Act.
Okay, so, and according to the rules, they are required to turn NCIC, TCIC to you for purposes of cross-examination. My understanding is the state actually gave it to you. Well, did you all give it to them well before cross-examination of the witnesses?
They gave them to us yesterday on April 1st, Your Honor,
All right.
and what.
Now, I will tell you, that is usually unheard of. Usually, in the past, the state would drop NCIC, TCIC immediately before cross-examination, not earlier in the day.
I think, two things, Your Honor. While that's maybe the court's practice, I think realistically, as a former defense lawyer,
Mhm.
you understand that the records are not themselves admissible, so counsel may need them in a little bit in advance. And by the way, we're not arguing about timing, because I want you to know that
Mhm.
the state did tender them to us, and we're not arguing that was untimely. And the issue is whether we could copy them and retain them for use during the proceeding. And what I was gonna advise you, those two cases, Monk and Watkins, just say we're entitled to just discovery of them. I believe that the state has provided us with discovery with them, and I want to compliment them. Here is where the issue is. Whether we can use them during the proceedings, I think, requires us to have copies, and there's a conflicting provision in 3914A. It says we're entitled to copy these documents, and there's the last sentence in 3914 subparagraph A is subject to any applicable privilege.
All right, so,
And Manfred,
Yes.
go ahead.
no.
No, you're the person that got to.
No, what I was going to say is the court is not going to allow the defense to have copies or leave the courtroom with the NCIC, TCIC.
Right, and I'm trying to make a record. And
Sure.
Just, obviously, we will abide by this court's ruling. I want the court and counsel to know that. Secondly, I'd like to make a record as to why we think that that's wrong. As I mentioned in my opening briefly, we can disagree agreeably. I would like to point out, Your Honor, that the provisions are confusing, because in 3914 subsection H, it says that we're entitled to any and all Brady material. And if you notice in the Watkins case, the court does recognize this as Brady material. And if you look at Bagley, Giglio, never understood how to, but I can spell it Giglio.
Yes.
I've heard it pronounced all sorts of ways. But in Brady versus Maryland and his progeny, Giglio and Bradley, the courts have said we're entitled to it not just instantaneously, but in time to be able to use it. And the problem is while we're in the courtroom, it is impractical for us to actually use the information on that realistically in order to prepare for cross-examination, because the rap sheets, I'll just say for NCIC and TCIC, are not admissible in themselves of the business records. What you need to be able to prove is the substance of what they're saying. So we've got to do some investigation and produce that information. While it does help to be able to ask a witness, is it in fact true that you were convicted on such and such a day? Or if it's relevant as a 404B, other crime or misconduct, is it true that you committed this offense if it's just an arrest or something like that? Then you got to go and get the substantive evidence so you can extrinsically offer it into evidence. And that's what we're suggesting, is that we would like to have that opportunity. And if we're not, we believe that that violates the spirit of Brady and his project.
All right, thank you so much.
You're welcome.
So, yes,
If I may just briefly respond, so, with
Megan,
this-
give me one second. Okay, go ahead. Sorry.
Okay, so just, I just wanted to cite some statutes. So I have a federal statute, it's 28 CFR Part 20, which governs the release of NCIC, TCICs, and then also the Texas Government Code, Section 411.083, which both govern the decimation of criminal histories, and they specifically accept agencies which are allowed to keep them in their custody. Defense attorneys are not listed in that. I am happy to provide them with a copy to review in court, but just like Mr. Hunter stated, he would not like to be charged with a misdemeanor. I would not like to either, and so that is the reason for our position.
all right, so with regards to,
Judge, may I
I don't,
respond briefly?
okay,
Counsel for the state brought up section 411.083. I would just would like to make the court aware of section 6 of that statute, which states that an individual or an agency that has a specific agreement with a non-criminal justice agency to provide services related to the use of criminal history record information disseminated under this subchapter, if the agreement specifically authorizes access to that information, limits the use of the information to the purpose for which it is given, ensures the security and confidentiality of the information, provides for sanctions if a requirement imposed under paragraph A, B, or C is violated, and requires the individual or agency to perform the applicable services in a manner prescribed by the department. As Bexar County attorneys are subject to the Bexar County discovery rules, we both agree to a contract for relating to the dissemination of discovery information, and are similarly bound under 3914 and the Code of Ethics, which directly relate to this issue.
all right. So the court is not going to allow you to copy or leave with the NCIC, TCIC. All right, so back to the other motion.
Yes, Your Honor.
Yes, counsel.
The next reason we are arguing that the cell phone should be excluded from the trial of this cause is based upon issues related to production. As I explained a little while ago, before we segued to motion to suppress, in February and in late January, we were discussing matters of scheduling in an off-docket conversation, advising the court that we were having some concerns about one of our experts and that we might be needing to seek a postponement of the trial date. When that occurred, which I believe would have been, it was certainly after January 15th, but before January 31st, the prosecution came up to me and advised me that they had a new cell phone dump that they needed to provide me. And I received an external hard drive the next day, I believe.
All right, and what approximately, when was this?
This was in late January of this year, in 2025. which we then filed supplemental briefing on in our motion for continuance in for the February trial setting, explaining that a cell phone dump is a very voluminous and large amount of material. It's very cumbersome and time consuming to go through it. It requires expert consultation, especially if there are deep concerns about the material on it, and that we weren't going to be able to do that in the time period afforded. The court at that time indicated to us, I believe at our formal trial docket setting, while we were urging our motion for continuance and the supplement, that if the cell phone dump was going to be a problem, then the court might entertain the fact that it would not be admissible because it's untimely produced. Understand that this dump has been tendered to us 7 years after the seizure of the phone. It's a little more complicated than that, though.
So have you been on this, how long have you been on this case?
The earliest piece of correspondence I have about this case is in 2018, when Mr. Goldstein and I believe, were first retained.
All right, and so that was when you were, when it was in juvenile court, or was it in a different court?
Juvenile court, yes, Your Honor, and it was, I believe, our discovery request may even predate his actual physical transfer of custody to Bear. So would have been still up in the air, as it were, whether he be certified formally by the court as an adult in this trial.
Right.
In any event, Your Honor, it should be stated and be clear, a dump was tendered to the defense counsel a long time ago. I can't say whether it was in 2018 or 2019, but a cell phone dump was tendered at that time. That dump was a technical extraction of the data. It was in a PDF format. A lot of file folders or a lot of documents that were listed within that PDF format.
All right, and when was the dump done?
The
that
dump
was
was in
tendered to you.
2017.
So in 2017, there was a cell phone dump.
Yes, Your Honor.
Extraction.
An extraction.
Okay.
Um,
And did you have access to that extraction or no?
we received a PDF format copy of it, which we reviewed and we largely found to be sort of unintelligible.
All right, and so that was in 2017.
That's correct. Strategically, we felt that that level of extraction would probably be advantageous to us, because our argument could be that the way in which the data was extracted leaves doubt as to certain key questions that may exist on the phone. In other words, we felt that the work of the police was insufficient to merit a great deal of additional attention to the matter. And we didn't have many discussions about the cell phone afterwards. Then in 2025, in late January, we're provided with another dump. We have been trying very hard, and I still do not know this definitively, but we've been trying very hard to compare and contrast it with what we have been previously tendered, which is a time-consuming process because it's like a 4,000-page document. That effort, I mean, they appear to be very, very similar in nature. And we also engaged a expert consultant to help answer some key questions that we as technological Luddites don't know about why it's in this format, why it's so difficult to understand the format. Why can't we just get a UFED Cellbrite reader dump where we can go on our computer and open Snapchat folders and open Instagram folders like we would for a dump in 2025. And what's been explained to us is that this is a technical extraction. It is the lowest tier type of extraction. In other words, it's a summary of the information. It isn't really the full contents.
It is not the current Cellbrite, that's CELEBRITE.
And let me
Extraction.
correct for the record. I have said technical extraction. That is not the right word. It is a logical extraction.
All right, just one moment off the record. Who are the people? This is students from a school, I think. For mock trial? All right, just give me a moment. All right, you may, please find a seat. All right, you may continue.
Thank you, Your Honor. Suffice it to say, between our efforts internally with my office to try and compare and contrast the new dump with the old dump, and then getting an expert to help us sort of better understand exactly why the discovery is in the state that it's in, we have consumed both man hours in my office that could be spent with other aspects of Mr. McIntyre's case. And we have spent Mr. McIntyre's money on trying to determine whether or not this is something new and what exactly about it is different than what we had previously ascertained. And while it appears to me that there is nothing new, I can't say that with absolute certainty yet. The problem we have here and the basis for our motion for exclusion on this motion is that under Heath and Watkins acknowledge that 3914 requires timely production of discoverable material. And that this has complicated the question of the dump, whether the dump
So the
comes
dump
from-
that occurred in 2025 that you're saying occurred, that seems to be similar to the dump that occurred in 2017. What month in 2025 are you saying that you received that?
It would have been in February. Or I believe, or it would have been,
February,
whatever the date of our last docket appearance, it would have been the Friday before, I think. And state, please correct me if I'm wrong about the exact timing of that, but it was around that day.
And Your Honor, the expert that Mr. Hunter has described is an individual by the name of Eric Devlin. He's a nationally recognized digital forensic expert. His affidavit is attached to our motion, which points out the fact that it is unusable in the current form and that he would require at least until the end of April to be able to even determine whether it can be turned into a useful format.
all right, and I'm sorry, just so I can have the dates clear, counsel.
Yes.
So the Friday before would have been January 31st. The court shows that motions were scheduled in this case for February 3rd. So because you're saying it's the Friday before was January 31st.
And it wouldn't have been that date because I was in a trial in another court that date.
All right, so
I-
I'm just saying that's the day before. That's the Friday before February 3rd.
And John, I don't want to interrupt you, but I have email correspondence from us from January 28th. So I think it would be fair to say it was somewhere between January 28th and February 3rd date for motion.
That sounds roughly what my recollection of it is. Your
All
Honor.
right, so-
And I need to correct something else because I'm just not very technically savvy.
No,
so
no, no,
I said
so-
something wrong.
So my understanding, and I'll give you a chance to correct, I'm just trying to make sure I have the dates in my mind correctly. So your correspondence is somewhere between what dates?
The correspondence between me and Mr. Hunter's office was from January the 28th. And so I believe it's fair to say that it was turned over in between January 28th, 2025, and then the February 3rd, 2025 hearing date.
All right, and so do you agree with that defense that the information would have been given to you between January 28th, 2025 and February 3rd, 2025?
That tracks with my recollection. I believe that's right. Yes, you're right.
Okay, and I'm just, for both parties, I'm just trying to get all of the facts so I can make an informed decision on your request. All right, you may continue. And you said there was something you wanted to correct?
Yes, so there is one difference between the 2017 and now, and that is that we now have the raw data for a logical extraction, the lowest level of extraction, which was not provided in the 2017 extraction. But to be clear, it's the same extraction. In other words, it isn't as though the phone was worked over again in 2025 or 2024 or something. It's just that additional information that is attendant to that original file has now been provided. And that's that. So I just wanted to correct that.
And I believe in the motion and affidavit, it would appear that we did hire Mr. Eric Devlin, excuse me, shortly thereafter, after the February 3rd hearing. And he examined the material, attempted to use it, and the affidavit attached as Exhibit 1 to our motion that the court has before it is dated February 30th. which will indicate that he was working diligently until that time, and he set that out in the affidavit.
All right. And so my understanding from what the defense has informed the court is that you received data in 2017. And at that time, this case was not before this court because it was in juvenile.
That's correct.
And from defense argument, or what the defense is telling me, is that in 2017, you received a PDF for this cell phone dump. Is that correct?
That's correct. I don't know what, so I think that we requested discovery from the former prosecutor while this matter was being transferred to Bexar County and awaiting in juvenile on March 1st of 2018. So it would have been sometime in 2018 or 2019 that we received the original extraction.
All right.
Which,
So,
by the way, was not in a usable format.
no.
Yes.
This is what I'm asking. So 2017 or 2018, you received a cell phone dump. And that was when your client was in juvenile court, correct?
Right, it was a PDF of a cell phone dump.
PDF,
Not
all
the
right.
actual dump.
Not the actual cell right.
All right. And then you received that PDF and you state that what was turned over to you in adult court, and I'll just call it adult court so that the record can be clear, appear to be similar, but you're saying maybe it's not similar. But the information that you receive in juvenile court from 2017 to 2018, you stated that it appeared to be unintelligible.
Right, we couldn't make any use of it, right?
No.
So you see entries and the PDF.
No, I understand. You're just saying it was,
We can't
yeah,
dive deeper.
yeah. All right. And so you said it appeared to be unintelligible. But what you said was you were fine with that because as a part of your strategy, you're fine with that.
My thinking was if I can't make heads or tails or make much use of this, then they can't either. And that there would be good arguments under the rules of evidence to exclude different portions of it. And that we would at a minimum have good argument about the true context and meaning of what those things on the phone actually stand for because of what isn't there. That was the original thinking at the time.
Okay.
The problem we face now is that we've been given a version of it with a UFED reader so that there can be deeper inquiry into what it contains. But it's a cell phone and it's a lot of material. I haven't been able to go through all of it. And what I worry is that there's going to be something on that phone that I have not seen or don't know about that's going to be used by the prosecution to advance their position and that I have no way to rebut or be prepared to attack.
And under the Michael Martin Act, if it is relevant, we're entitled to it. So we would like not just the entire 4,000 pages, which contain terabytes of information.
So here's
perhaps.
my
We
question.
would like to know if the state has anything that they intend to use, they believe is relevant. We'll take their word for it. We would just like one, to be advised of what they think is relevant. And two, we believe it is untimely because we can't go look for stuff that might help us. We've got an expert trying to do it.
But here's my question
Yeah.
for the defense. If you have information in 2017 or 2018 that you're saying, it's unintelligible, and as a part of strategy, we're not going to ask or receive it in any other format because that's a part of our strategy that if the state tries to use it, we can argue, hey, we received it, it's unintelligible. So you're saying,
Think about it in this context.
no, I'm just trying to clear up.
Right.
Because I want the record to be clear. So everyone's argument can be understood by me and whomever else needs to hear the argument.
Right.
So how does Michael Morton Act purport with defense, perhaps saying with strategy for strategic purposes, for trial purposes? I know this is unintelligible, but I'm not going to say anything. And then when it comes to trial, I can argue, you know what? By the way, guys, this is unintelligible. I knew it was unintelligible in 2017. And as a part of my strategy, I really wanted to remain unintelligible and nobody to figure out that it was unintelligible for us or our expert, so that at the time of trial, that can be my argument.
But
Well, this is-
actually, Your Honor, I know. Actually, Your Honor, we're not saying, it was our strategy, because if somebody gives you a blank piece of paper.
Yeah.
Or a book and just says here, we don't have possession of the phone. We can't do anything with it. And if that's all they're gonna use, they're not gonna be able to use it either. So it wasn't that, it's like, we have probably gotten terabytes of jail calls. I don't think anybody in this courtroom, prosecution or defense, has listened to every jail call. It's just not usable. What we got was something we couldn't use, and we assumed they couldn't use it either, and we didn't have custody of the phone. We couldn't go do any additional thing. What happened is, all of a sudden, we get something that is actually slightly different, in that they apparently have figured out how to use what they had, not what they gave us. We couldn't do anything with that. No experts could do anything with a PDF. That's just a copy of something. And so what I'm suggesting is, we didn't know that there was anything relevant or material. If they think there is something relevant or material in that, we'd like to know, because we would like our expert to look for other things on there. If they're able to find things on there that they think are relevant material, we'd like to see opportunity, Your Honor. That's all we're saying.
No, no,
And
no.
if they don't
And-
think there is, then we don't want.
And let me just tell everyone, I ask questions, and the reason why I ask questions is because I want the record to be clear.
Right.
And I want to be clear on your argument and what your argument is. That is why I'm asking these questions. It's not saying that I have I've already decided on which way I'm going to rule. I just want all of the questions answered in my mind so that I can make an informed and intelligent ruling.
I think that's fair, Your Honor, and I didn't mean to imply that we.
No. Yeah,
I guess,
no, that's why I'm just saying that. These are just questions I have.
And I wanted to make sure you were characterizing what we were trying to say.
Oh, no. I'm not. I'm just asking questions.
I know what you were saying. Is this what you were saying? And I was just trying to say, that's kind of what we were saying, but I wanted to point out the fact that if somebody gives you something you can't use in evidence, that they couldn't use in evidence, it's useless to everybody. But if they think there's something in there that we could have used, and they found something, I'd like to have the same opportunity, that's all.
And that is why I brought that up and was asking questions about it, because your co-counsel was saying that it was strategy. But now
Well, it
you've given your explanation
Of
that
the
it's the
strategy.
same if you receive a blank sheet of paper. Your strategy is it's a blank sheet of paper. They don't have anything because it's a blank sheet of paper. We don't have anything, so we're not going to bring it up. I understand that. Okay.
and what I would equate it to is, let's say that as a case starts off, we have received discovery that there's been swabbing done for
Mhm.
biological fluid, but no results are in, right? And so we know that there are swabs, but we're just proceeding on our course. We're getting ready for our trial. Then later we get a notification, oh, by the way, serology's back. This is human blood. It isn't chicken blood or something. Okay, well, we're still proceeding to trial. Thanks for letting us know. They don't know anything more than it's human blood. So if the trial happens today, then that's all they're going to be able to say. And there's nothing else for us to do. But now they've given me the full DNA breakdown.
So
with
you,
the bench
so
notes and
defense, what you're
everything else.
asking for is you're asking for the information to be excluded because you're arguing that it was given to you untimely.
Yes, Your Honor.
That
Right.
and the fact that we don't have the ability to do anything about it, because in the form they've given it to us, our expert says it's gonna take him at least another 30 days
Okay.
to be able to use it.
All right. And when did you give this to your expert?
But that's what I was saying.
March 3rd, Judge, and if I may.
Actually, it was in February, because his affidavit is February 30th.
Wasn't able to get to it.
Let me just kind of explain that real fast. Then, Mr. Lane, I would like to have one thing added to it. the first thing that we needed to do was when we looked at it, it looked an awful lot like what we already had. And so it was like, okay, is this different? Is this the same? Is it the same plus something else? And we sorted that out, and then it was like, okay, I don't really understand what's going on here. We need to get an expert. That's what I wanted to clarify.
And we got him. We got the expert in February. Obviously, shortly after we received the material. And the expert says he needs considerable additional time.
So you would have obtained the expert sometime,
It was
uh,
early March, March 6th, I think, March 2nd.
Or third, somewhere in that range. It's in the affidavit. And I just would like to make something abundantly clear for the record. Two pieces of evidence that we're discussing, the PDF that was provided subsequent to the 2017 extraction and the subsequent extraction that was provided to us in late January or early February of this year are different pieces of evidence and have contained different things.
All right, so-
The original document that was provided to us is a PDF, so it does not contain, the ability to interact with video files, to enhance or enlarge or manipulate photos, to follow any attachments, to listen to any audio. Okay, it's a PDF. It's just a paper printout of the data contained on the phone. The information that was provided to us in late January or February is the raw data of the extraction, a logical extraction of the phone, and a UFED reader format. So that is interactable on Celebrite, and so that you can then access all of this additional information. So I want to be very clear, these are different things, and there's different information.
no. So what I want to know is, I think both parties have agreed that the information that was given to the defense in 2017 was when Mr. McIntyre was in juvenile court.
Yes.
Then we have more data, or maybe the same data, but in a different format that was given to the defense January 28th, 2025, or somewhere between January 8th, 2025 and February 3rd, 2025. Somewhere in that time frame, that's when the data was given to you. And I think everyone has stipulated to that. Am I correct?
That's correct.
And I
All
want
right,
to correct
and then-
myself, Your Honor.
Yes.
It is, the affidavit is not February 30th, but March 30th. Your Honor.
Okay.
Uh,
And then, so,
I don't want to get the numbers.
oh, no problem.
It was 3:30 and I took that.
Oh, no, let me just tell you, it happens all the time. So then, so you stipulate the information was given sometime between January 28th, 2025 and February 3rd, 2025. In addition to what was given in 2017. And in the data that was given to the defense between January 28th, 2025 to February 3rd, 2025, some of it was the same as what was in 2017. And there may have additional information that was given
I think
instead of just 2017 information.
a better way to describe the relationship between what was given then and what was given now would be to say that it would be the difference between running the program and being able to manipulate it with your mouse, your cursor.
All right, so this is what I'm saying. Everyone, listen, please listen. What I'm saying is you all received data in 2017. In addition to the data that you received in 2017, you received data in between January 28th, 2025 to February 3rd, 2025. Both parties have agreed upon that. The state and the defense have agreed upon that. The data that you received in 2017, you received that data between January 28th, 2025 and February 3rd, 2025. And there may have been additional data related to the cell phone between January 28th and 2025 and February 3rd, 2025. I think both parties agree upon that. Am I correct?
Yeah.
Yes.
And we can't use either one of them.
Well, no.
in the
Let me,
court.
let me just take it step by step so the record can be clear. Then the defense, you have this data and you have your expert. I believe you said March 30th, 2025.
Well, we got him actually at the
March
end
6th.
of February, early March. And the affidavit is after he has spent that time, the month, trying to use it. And he says he will need additional time. And what I'm advising the court in the motion is basically, here's an easy solution. If they're not gonna use it, we don't wanna use it either. We don't know that it has anything because we can't use it. If they are gonna use it, we'd like to know what they wanna use, and we'd like additional time to be able to develop what we need.
All
And
right,
that was the
so,
purpose of our motion for continuance the last time.
February, when did you all have your expert look at this data?
We sent the data to him on March 6th or March 2nd. I think it's in the affidavit.
All right, so March 6th, we'll just say March 6th, you send the information to your expert, correct? Even though you had the data at the beginning of February, am I correct?
Well, what we did first, Your Honor, was we were
Tried to
looking
use
at the data to see if it was the same as what had been previously sent, because what was confusing was, wait a second, how is this different from 2017? I don't understand exactly how it's different from 2017. We were trying to avoid the need of incurring the expense of having an expert consult with us on it if it was going to be the same data and it just, was called something else.
All right, state,
But that wasn't the case.
Judge, okay, so
And by the way, it is March 6th, Your Honor. It's paragraph 12 of the affidavit.
all right, thank you. Yes,
So it is my understanding that there was, and I would still classify it as one phone dump, okay? The phone dump regarding that blue cell phone that was located in the Kia Forte was conducted back in 2017. What was given to us by the law enforcement agency was a CD containing the PDF of the Celebrite extraction report. That was turned over to them and that has been stipulated to them back between 2017 and 2018. Upon my assignment to this case, when I reviewed the PDF, I started looking at it and I wanted to click on the PDF. It's intelligible. It contains call logs, device information, images, and things that were contained on the phone. When I was looking at the images and some of the sounds on there, I noticed that there was thumbnails that I would try to click on and would not open. Once I realized that, I contacted the detective to see if he had a master copy or if it was just an error in the way that it was run. So close to that January 28th date, I went over to SAPD's CSI unit. They had a master copy. The only difference, my understanding, because I don't have an expert, I have to lean on my own understanding, but when I look at it, the page numbers are the same. All of the information that is contained within the PDF is the same. However, now when you go and click on the thumbnails, you're able to see the actual image or listen to the sound that was contained in the original PDF.
And
That's
makes it
the problem, is because we have to rehash the same 4,000 some odd page document that we previously had and make sure that whether or not each of these thumbnails works. So the idea is, you can look at this and say, well, my gosh, it's been 7.5, 8 years. But understand that this is a very lengthy, time consuming, monotonous process to get completed.
all right, state, do you have information that you're planning on using from the phone?
I do, Your Honor, and if you would like to just exclude from whatever was turned over and we can just go on to 2017 that they've had for 7 years, I'm completely fine with that.
All right, if you would inform the defense specifically what you are seeking to use from the 2017, and you're saying that the defense says it was unintelligible. You're saying that's not the case?
It's a PDF and read what is on it.
All right, so if you will inform the defense of what you're specifically seeking to use from 2017, and then I'm going to have you all come back at, I'm going to say 1:20 because the jurors are going to be here at 1:30. And then I'm I will make my ruling on this part of your motion. So if you all can confer on what you're seeking to use from 2017 that was given to them in 2017. And then I will hear a final argument once you all see what they're saying that they're intending or want to use from 2017. Then I'll hear your final argument in regards to that. The state is saying that the information that was given to you, that's additional information from January 28, 2025 to February 3rd, 2025, they will not be using that.
Here's my
And- and
concern.
Your Honor-
No. This is what this is what I want everybody to do. Hear me clearly. The state is going to tell you what they're seeking to use from 2017. Your co-counsel has stated, we'd like to know what they're going to be using. So what I want you all to do, and I don't want to hear anything else. What I want you all to do
You tell me
is,
what I said.
no. What I want you all to do, hear me clearly.
Right.
State, I want you to show them what you are seeking to use from 2017. I'm not saying I'm letting it in. I don't know. I
May-
want you all to see what they're saying they're going to use.
May I have
You-
one clarification, Your Honor?
No. Y'all, I'm sorry. You are going to come back at 1:20, and then counsel, you can put your clarification on the record.
Right.
So you all can come back at 1:20, and the jury will be here at 1:30. But I want you all to see what they're saying they would like to present. And then I will hear your final argument based upon what they're saying they would like to present, and the court will make a ruling.
Thank you,
Understood, Your Honor.
and well, the only thing I would like to ask is, are y'all just offering things off the PDF? Or are
We'll
you
talk-
saying,
I think we can talk about it and.
okay, because I think it's not the PDF that we got in 2017. They have now figured out how to click
Oh,
on it.
no. They're gonna show you specifically what they have from what they had from 2017. And if it's something that you think was not given to you in 2017, that's something we can take up at 1:20.
Okay,
But I
and
think you all
Able
may,
co-counsel has something he wanted.
all right, here's the
to say,
thing.
we'll wait until then.
Yes, you all may decide that you're fine with the 2017. I don't know. So I want you all to have a chance to view it, then we can come back and discuss it. All right, so if you all can be back at 1:20, because the jurors will be here at 1:30, and then I will hear argument. If you all decide, no, we're fine with 2017, then we won't need an argument, because the state has already stated they will not go forward with information that is in addition to the 2017 dump. So anything that's additional that was given to you on January 28, 2025 through approximately February 3rd, 2025, they're saying that they're not going to use it if it's additional information. But if it's the same as the 2017, they're saying that they're wanting to use that.
That's
But
understood.
they're going to go over with you what they're seeking to use. And then we'll be back at 1:20, and I will hear all of your arguments.
Thank you, Your Honor.
All right, thank you. All right, who is here? Leo? And Mr. Guerra, have you had a chance to speak to your client? All right. So you all need to be back at 1:20.